Hello everybody, welcome, and thanks for joining me. Hi, I'm Gerry Oginski. In today's video, I want to share with you a story involving a 28-year-old woman who sued her orthopedist for what? For failing to diagnose her fracture when she went down a hill using her son's scooter. Come join me for a moment as I share with you some great information. Okay, so now here's the scenario. This was a young woman who was watching her son, her young son, play on the scooter. And the scooter was nothing more than, this little tiny scooter with a tall, flimsy handle. Has small little wheels. Okay, and now the kid kept going up and down the driveway. It was on a nice decline. It had a nice angle. And the kid would go on at the top, ride down, and guess what? He had fun. He was having a great time, and Mom was outside watching him. So, after a while, what do you think happened? After a while, Mom decided, hey, I want to join in too. I want to have fun too. So what did Mom do? She said, let me try. So she gets on this scooter, never having been on it before. And now as she's going on it, she's going down her driveway faster and faster and faster. And what do you think happens? Boom! She either hits a pebble or hits something in the middle of the driveway. And now she goes flying up in the air. And what happens then? She lands right on her elbow. Okay? So she gets hurt. And now she goes inside. She puts ice on it. And that doesn't do the trick. She takes over-the-counter painkillers. That still doesn't solve the problem. So what does solve the problem? Well, after a couple of days, she realizes, you know what? I need to go see an orthopedist. I need to see somebody. So that's exactly what she does. She goes to see her local orthopedist near her. And now he takes an x-ray. And what does the x-ray show? He comes out and he says the x-ray is negative. Everything's fine. So she goes about her day. He says, just do yourself a favor, put an ice wrap on it, put an ace bandage on it, put some ice on it, and everything will be fine. So that's exactly what she does, and she listens to him. Except here's the problem. Over the next couple of days, and even weeks, the pain doesn't go away. The pain gets worse. The pain gets worse and worse. And all because of that. She ignores that. She ignores the fact that the pain is getting worse and worse. Does she pick up the phone and call the doctor? No. Does she make another appointment to go in for follow-up? No. So finally, after 4 weeks of now going through this process, where now she's in excruciating pain, but she's able to move it, even with pain, what does she do? So now she makes an appointment with a different orthopedist. And that different orthopedist takes x-rays. And you know what he tells her? He says, guess what? You've got a fracture. You have a fracture here in your elbow. She said, how could that be? The first orthopedist I went to took x-rays, and he said I didn't have a fracture. How could that be? And the second orthopedist said, hey, could you get me the x-rays from the first orthopedist? And she says, okay, hey, Angela, nice to see you. I'm talking about this case involving a 28-year-old woman who fractured her elbow when she was on her kid's scooter going down the driveway. So she saw her kid riding this thing, having a great deal of fun. She said, hey, let me try it. So now she went down this thing, and at the bottom of the hill, boom, at the bottom of her driveway, she landed up in the air. Next thing you know, she lands on her elbow. Well, she first went to the orthopedist, who took an x-ray and he said, hey, there's no fracture here, it's just sprained. You can go about your business, just put on an ace bandage. Okay, so that's exactly what she did. Hang on. So now what happens? So 4 weeks go by, and she's in excruciating pain. The over-the-counter pain medications aren't working to alleviate her pain. And now she never bothered to call the doctor to make a follow-up appointment to say, hey, I still have this pain. I still have this problem. So what do you think she does? So she makes an appointment to see the second doctor, second orthopedist. And the second orthopedist takes x-rays and looks at her and says, hey, you've got a fracture. He said, didn't the first orthopedist see this? She said, no, he told me I had a sprain. He said, could you go get those x-rays? I want to see them. So she made arrangements to have those first x-rays brought over to the second doctor. And now the second doctor looks at them and says, it's right here on the x-ray. It's obvious. You have a fracture. She said, why is that important? He said it's important because if she had been treated, recognized with the fracture and treated originally when this first happened, she simply would have had a cast, had it on for a couple of weeks, and now her arm would have been immobile. And after that, they would have taken the cast off. She would have had some rehabilitation. And guess what? She would have been fine. But instead, because that was not done, because he didn't recognize what was going on, now she needs surgery. Now she needs surgery to go ahead and insert hardware into her elbow. Hardware including pins, a steel plate, and screws. And this hardware is going to be inside of her elbow for the remainder of her life. So the doctor tells her, listen, you need surgery, corrective surgery to fix this problem. Otherwise, you're going to have, the bone is displaced. Because you've been moving it around for weeks now, the bone has come detached from where it's supposed to be. And you can't have that. That's why you're having this ongoing pain. We need to get you into surgery to fix the bone so it stays in place and it doesn't move, or at least doesn't move position. Then we need to put you in a cast for about 8 weeks. Then when the cast comes off, then we need to have you go for physical therapy and rehabilitation. So she says, okay. Now, a couple of months later, she comes to me and says, hey, Mr. Oginski, I think my first orthopedist screwed up here. I think I need to bring a lawsuit against him. So I had my medical expert review all the records that I had accumulated, all of her medical records, including the x-rays, the orthopedist records, and other records that she had before ever going to an orthopedist. And he's looking at it, and he calls me up and he says, listen, there's a case here. There's a valid case. It's clear that the first doctor violated the basic standards of medical care. He failed to recognize that this patient had a fracture. Number two, failing to recognize the fracture and treat it at that time resulted in injury. And I said, what was the injury? He said the fact that she now needs corrective surgery, that she needs an open reduction, internal fixation surgery to fix the bone. Now, she would not have needed that if this was recognized initially when she went to the first orthopedist. So my expert told me, yes, we have a valid basis for a case. And that's what allowed me to go forward with a lawsuit on her behalf. Because you should know that in New York, we are required to get confirmation by a medical expert who confirms, number one, that there was wrongdoing. Number two, that the wrongdoing was a cause of the injury. There has to be a connection between the wrongdoing and the injury. And number three, that the injury is significant or permanent. Only then are we permitted to go forward with a lawsuit. Hang on, water break time. Okay, so what happened here? Well, as can be expected, when we brought a lawsuit against the orthopedist and his attorney turns around and says, hey, why are you suing us? We did nothing wrong. We treated this patient appropriately in accordance with good and accepted medical care. And then he said, you know what? I don't understand why you're suing me. I did nothing wrong. You should be blaming your client, the injured patient, for all of her problems. She created all these problems. She never bothered to come back to me. That was defense number two. So now he's pushing the blame off of himself and onto the patient. Number three, he says, you know what? If I did something wrong, well, guess what? Nothing I did caused or contributed to her injuries. She would have had those injuries anyway. Right? That's a powerful defense, especially if it's true. And I'll tell you ultimately whether or not it is, or what the jury said about it. So now, what's next? Excuse me. So what's next is that as a final defense, he turns around and says, hey, listen, not only did I not do anything wrong, but you, the patient, did something wrong. And even if I did something wrong, it didn't cause your injuries. And guess what? Your injuries are really not as bad as you claim them to be. So those are the four defenses the doctor raised in this particular case, which, by the way, are typical defenses that we see in these medical malpractice lawsuits. So now, this case was fought tooth and nail. Every time we said day, they said night. Every time we said it was 10 o'clock, they said it was 2 o'clock. Every time we said red, they said blue. No matter what we were claiming, they said, no, that's not correct. And they gave some other reason, some other explanation. So, throughout the entire 2 to 3 years of litigation, this was hard fought. And now that meant that her case was going to trial. The defense refused to negotiate. They wouldn't pay a dime. Not a dime. Why? Because they felt they did nothing wrong. Okay? Which meant we needed to get ready for trial. So my medical expert was willing to come in and testify. This board-certified orthopedist, somebody who was excellent, who had reviewed all the records and confirmed that we had a valid basis for a case. We get to trial. I put on my expert. I put on my witnesses. I put on my client. And then the defense puts on their witnesses, their expert, their witnesses. But you should know something very interesting. My very first witness in this trial, which was held in Brooklyn, in the Supreme Court of the state of New York, we call it Kings County Supreme Court, which is the trial level court in New York for these types of matters. My very first witness was the doctor, the orthopedist whom my client had sued. Now you may be asking yourself, how is it possible that I can call in my client's doctor, the doctor whom we have sued, as my first witness? Well, there are a number of ways to do that. One way is to serve a document called a subpoena on him, which compels him to come into court. The second way is to say to his attorney, hey, listen, I need your doctor as my first witness. We're starting testimony Monday morning. Please have him here. Okay? That's another way to do it. So there's the easy way and there's the hard way. Either way, the doctor's coming into court. If I have to subpoena him, now I can show the jury that the doctor did not come into court willingly. Instead, I had to force him and compel him. And the only reason he's in court today is because of this court-ordered subpoena that says he has to be here. On the other hand, if his attorney agrees to bring him in voluntarily, now I lose the benefit of telling the jury that he's here voluntarily. I can't accuse him of coming in unwillingly. He has now willingly come in. So that's a little strategy that the defense will use to say, hey, we'll be happy to bring the doctor in. We'll clear his schedule and we'll be happy to bring him in. Why do they do that? Because they don't want me to show the jury that he's there involuntarily. Okay, so now, during the course of my questioning, actually, let me go back in time. Before this case ever got to trial, I had an opportunity to question the doctor that she sued. This is a pretrial process. It's called a pretrial question and answer session, which is known as a deposition. And it takes place in his attorney's office. And you know what happens there? I get to ask him questions about what he did, why he did it. And there's no judge there. There's no jury there. There's just me. There's his attorney. And there's a court reporter there to record all of my questions and all of the doctor's answers. And all of his answers constitute his testimony, his pretrial testimony, which, by the way, carries the same exact weight as if he were testifying at trial. So now, even though it's in an informal setting and there's no judge or jury there, everything he says is put into a booklet. Everything's transcribed and then put into a booklet called the transcript. And you can be sure that everything that is said can and will be used against him when the case goes to trial. And how do we do that? We do that by showing the jury that the doctor has answered a question at trial differently than he did a year earlier when he gave his pretrial testimony. We use it to highlight and show contradictions. And this way the jury gets to evaluate the credibility of the doctor. They get to decide for themselves whether or not this witness is lying, whether or not this witness is truthful. And by highlighting contradictions between testimony he gave a year earlier in his attorney's office compared to what he's now saying to the jury, now the jury decides for themselves. All right. So during my opportunity to question this doctor, by the way, I get to cross-examine him, which is a high point of any trial, I was able to learn during pretrial testimony that this doctor had failed 3 classes in medical school, 3 different classes, and had to repeat the entire year all over again. Imagine that. Imagine that a doctor had to repeat the entire year. But that wasn't the best part. The best part, I thought, was when I asked him, what classes were they that you failed? Doctor, what was the first class you failed? I don't remember. What was the second class you failed? I don't remember. What was the third class you failed? I don't remember. Really? You don't remember? Doctor, I understand it's been 20 years since medical school. But for you to have to repeat an entire year's worth of schooling, medical school no less, you're telling me that you don't remember? That was outrageous. And I thought that when we got to trial, that the jury would think that this doctor was trying to intentionally hide something. So, let me share with you what exactly happened. So now, the doctor's on the witness stand. I am cross-examining him, and I'm asking him the same questions that I asked him during his pretrial question and answer session that took place a year earlier. And I said, Doctor, isn't it true that most medical students in New York, in the country, finish medical school in 4 years? He said, yes. He said, but you finished in 5 years. Isn't that true? Yes. And the reason why you finished in 5 years is because you had to repeat an entire year. Isn't that true? Yes. And the reason why you had to repeat an entire year is because you failed 3 separate classes. Isn't that true? Yes. Doctor, what was the first class that you failed? I don't remember. What was the second class you failed? I don't remember. What was the third class you failed? I don't remember. So I gave the jury questions that would allow them to evaluate this doctor's credibility. Was he being honest? Was he being truthful? And even though this doctor had been in practice for 20 years, I felt that this was a significant point that would somehow impact his credibility. So what do you think happened? What do you think occurred here? The defense argued in this case that my client's injuries all came about because of her own carelessness, getting on her kid's scooter, going down this hill, and now, because she'd never been on it before, didn't know how to use it, she was the one who caused her injury. She should be held responsible, not the doctor. The doctor also was arguing, hey, listen, why are you here? Even if I didn't recognize this problem. He's saying, she has no real injury now. She's fine now. Her damages are limited to just having the surgery. And by the way, there's still the possibility she might have needed surgery to begin with anyway if the fracture did not heal and did not take. So their argument was pretty powerful. They were basically saying, hey, listen, she still would have had an injury, and we didn't cause the injury, but they're saying, nothing I did caused or made this injury worse. My expert said something totally different. He said, in fact, the four-week delay did in fact make a difference. She would not have needed surgery had this been recognized early on. So, what do you think happened? We're in Brooklyn. We're in Kings County Supreme Court. We try this case. I put on all my evidence. The defense puts on all of their evidence. And now the jury has to reach a decision. And the decision they have to reach, it's not just one global decision about whether we're entitled to a verdict in our favor. There are 3 questions that the judge is going to ask the jury to evaluate. 3 separate questions. So let me tell you what they are before I tell you what actually happened. The first question is, was the defendant negligent? Was the doctor careless? Did he violate the basic standards of medical care? If the answer is no, case is over, finished. Client gets nothing. If the answer is yes, the jury then has to answer the second question. Was the doctor's carelessness a cause of her injury? We call that in law proximate cause, right? Was the doctor's negligence a proximate cause of the patient's injury? Yes or no? If the answer is no, case is over. Patient gets nothing. If the answer is yes, then the jury must go on to answer the next question. And that is, how much money is she to receive as compensation for all of the harms and losses and damages that she incurred because of this doctor's carelessness? And there are different elements of damages, such as pain and suffering in the past, and the suffering and the pain that she'll endure into the future. But that's a topic for another video. So, now you know the 3 basic questions that the judge has asked the jury to evaluate. And what happened in this case? I'll tell you what happened. The jury reached their decision. They came to the conclusion that the doctor was not careless. That the doctor was not careless and did not violate the basic standards of care, which meant the doctor won the case. My client did not. The jury felt that we were not able to show that we were more likely right than wrong than what we were claiming is true. Now, here's something interesting. You should know that after a verdict, I have an opportunity to go ahead and talk with the jurors, assuming they stick around. They don't have to. But I have the chance to try and talk to them. Why? Why would an attorney want to try and talk to them? To understand what's going on in their mind, to understand what they were thinking as they were deliberating, to understand what they're thinking as different witnesses are testifying. So sometimes it gives us a great window into what their thoughts were and what the deliberation process was, because there's no camera in there. We're not in there when they're deliberating, deciding whether we're entitled to a verdict in our favor. So the next best thing is to talk to them afterwards, assuming, of course, they want to stick around and chat with us. They don't have to. And in fact, the judge tells them they don't have to. Excuse me. All right. So I wanted to talk to them. I wanted to find out what was going on in their mind. And you know what they said? They made a couple of interesting observations. The first one was, what was the first one? We didn't believe your client, in the sense that they didn't like what she had to say. They thought that she was fully responsible for causing and contributing to her own injuries. That's problem number one. The second big problem that we had, which I knew was a deficiency in our case, was that she had no ongoing permanent injury. There was no ongoing disability, no ongoing problems. In fact, she was asked questions during cross-examination, which basically said, hey, what problems do you have today? What things can you no longer do today? And you know what she said? I can do pretty much everything. Well, I'm cringing inside when I heard that, and I imagine that the jury was doing the same thing, and that's exactly what they were thinking. So ultimately, the jury decided that my client was not entitled to a verdict in her favor, and she went home without a dime. Now, the other option that she would have was to go ahead and try and appeal the case, and she chose not to. Why? Because she felt that there would not be sufficient grounds to appeal on a legal basis. The key problems here were factual. And you should know that the jury are the fact finders. These jurors are the ones to determine who they believe, who they don't. So if the jury decides that they like my client, great. If they decide they don't, well, that's a problem. And that's exactly what happened here. So why do I share this great information today? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases that occur here in New York. And you know, I understand you're watching this because it's coming up in your Facebook feed and you're scrolling through to see what's going on with your friends. Or you're watching this on a replay and you're specifically searching for information about how these types of cases work. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, thanks so much for the thumbs up. And you're thinking about bringing a lawsuit, but you have questions that still need to have answers, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, you can reach me. Let me go back. You can reach me at 516-487-8207. You'll see it in the description. Or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I hope you enjoyed this. And if you do, share it with your friends. Give it a thumbs up. And that's it for today. Have a wonderful day. Take care, everybody.